Get ready, start. Learned counsel for the petitioner raised several issues and contended that the principles of natural justice was violated with impunity, which caused prejudice to the petitioner and therefore, the impugned orders stood vitiated. Stop. The learned counsel submitted that a show cause notice was issued for the incident which occurred on 16/9/2007, whereas the petitioner has been expelled, taking into account his previous conduct and taking into account the intelligence report for which the petitioner was not put to notice nor an opportunity to rebut the allegations made in intelligence report was given. Stop. The non-supply of the intelligence report and by not providing an opportunity to rebut these documents seriously prejudiced the petitioner, which was in gross violation of the principles of natural justice. Stop. The learned counsel further submitted that the intelligence report, which was relied upon by the disciplinary committee, was not signed by any person and had been prepared subsequently, and therefore, no cognizance on this report could be taken into consideration by the disciplinary committee. Stop. The learned counsel further submitted that the circle officer had certified that the petitioner was not involved in the destruction of the university and that the petitioner was given a clean chit and was absolved from the incident, which unfortunately had been discarded by the disciplinary committee without assigning any valid reason. Stop. The learned counsel for the petitioner further submitted that the resolution of the executive council was also liable to be quashed as it suffered from various infirmities. Stop. The learned counsel submitted that the quorum of the executive council was incomplete and therefore, the resolution of the executive council stood vitiated on account of the mandatory non-compliance of having a proper quorum for holding a meeting. Stop. Further, the Vice Chancellor not only chaired the meeting of the Executive Council but also participated in the deliberation and voted for the resolution, which action of the Vice Chancellor was totally illegal since it was his own order which was challenged in the appeal. Stop. The learned counsel for the petitioner submitted that the Vice Chancellor could not be a judge of his own cause and therefore, the resolution of the Executive Council stood vitiated on account of this fatal error. Stop. In support of his submission, the learned counsel for the petitioner placed reliance upon a decision of this court in Daya Shankar Gupta versus Aligarh Muslim University, Aligarh and others. 2014 11 SCC 49. Stop. Para. On the other hand, Sri Sasi Nandan, the learned senior counsel, submitted that the petitioner raised no grievance against the intelligence report before the appellate authority and therefore, it was too late for the petitioner to raise such technical infirmities which, in any case was removed and that full opportunity was given by the grievance committee to the petitioner to dispute the correctness of the intelligence report. Stop. The learned counsel submitted that in spite of an opportunity being granted, the petitioner could not point out any error in the intelligence report and that most of the allegations made in the intelligence report was admitted by the petitioner. Stop and over.